No one will own the foreshore and seabed, but the door will be open to have customary rights recognised. That's the plan if the government's proposals to scrap the controversial Foreshore and Seabed Act are adopted. Is it the chance Māori have been waiting for? Joining me now from Whanganui is Maori Party co-leader Tariana Turia to help answer that question. Tēnā koe Tariana, and thank you for your time.
Tēnā koe, Shane.
Part of the preferred option, the government's preferred option, is to get rid of this Crown ownership concept. Now, that caused an outcry back in 2004. That's a good place to start, do you think?
Well, it's a good place to start, but in the option they're talking about public domain, and iwi are concerned about exactly what does that mean and kind of where it fits. I think the non-ownership option is a good place to start because then iwi can traverse what they believe are their property rights that exist today.
This concept of public domain, I don't own it, you don't own it, nobody owns it. What sort of concept is that? Your personal opinion of that concept?
Well, I think what it was an attempt to do was to remove the notion of Crown ownership. And if we look at the previous legislation, even repeal would not have removed Crown ownership. So there was a thinking within government that it was really important that we started from a neutral position. And the feeling was that public domain would be that neutral position. Though, as I said earlier, there are iwi who are very nervous about exactly what that means.
Do you think someone should own it?
Well, pre-1840 somebody did own it, Shane, and that was the various hapu and iwi who were coastal peoples during that time. So there was ownership at that point, even though we don't use that language. We talk about kaitiakitanga. One of the difficulties, I think, is that when we use cultural language, then it gets defined by others as to what that means. And so property rights, which is really what it is all about at the end of the day, that becomes, I think, a bit submerged within these cultural contexts that we use, such as customary rights, customary title. But at the end of the day, they are both still property rights and law.
Is an example of that confusion or misinterpretation a comment like Minister Finlayson has said, because he talks about a constrained or limited property right?
Well, therein lies the problem. I think that if we think that customary rights and customary title are lesser property rights than what others have in terms of ownership around foreshore and seabed issues, then that raises serious concerns for the various hapu and iwi who are affected, because they see their rights as being sacrosanct in the same way as those others who have private property rights in the foreshore and seabed. I do think that there are some difficulties when we use a cultural context to describe our rights. I think it would have been far easier had we said very clearly right in the beginning that there were ownership issues, and that's what we would be canvassing with the Crown right from the word go. However, though ownership is not a word that our people have used, and they have talked about these other rights, and as I said, in law, they are exactly the same as property rights.
Because some iwi and hapu are now talking about that concept of ownership as in the sense of pre-1840. Do you think that Māori should be able to explore their ownership rights?
Well, they can. What will happen through this process, and it was taken away by the previous government, is that they can go to court to explore those rights. And I think the really good thing about let's just clarify that. Let's clarify that, because I dare say the Minister will be listening to this and thinking, well, no, they're not going to be able to explore their ownership rights, but more their customary rights. Is there a difference between the two? Well, as I said before, I believe that they are still property rights. They still are property rights. I think that the difference is that in the Pākehā concept of property rights, you get a fee simple title. whereas in the cultural construct you get the property rights, but because they are collective, they're not owned individually, they are customary rights and customary title.
What's the difference? What's the underlying difference between the two?
Well, I think one's individual and the other one's collective.
But also the ability to be able to sell the land, that's a big difference too, isn't it?
Well, that's true, because under fee simple title you can. Under customary title and customary rights, what's happened is that that's been made inalienable, and so the land can't be sold. It would always have been difficult anyway, Shane, if you've got collective ownership, to get an agreement from all of the owners that a sale could take place. And so I think it's a way of protecting the land, which I believe that our people want anyway.
Do you think that full Māori ownership is a political reality?
Sorry, I'm not quite sure what you mean by that.
Full Māori ownership. So, for example, for a hapu or a tribe to be able to test their rights, whether it be with the court or whether it be with the Crown, but because some of them are actually saying they want full ownership. Do you think that's a political reality today? Do you think that would ever happen?
Well, if you look at particular tribal groupings where they have maintained their mana over those areas because their land abuts all of those areas, like Ngāti Porou, like Whanganui, there's areas of other areas throughout the country where there are coastal iwi who have always maintained ahika and their mana remains the same. I think that in those particular areas that they will be able to prove ownership or customary title and customary rights that exist today. I mean, the three areas that iwi wanted to explore were the issues of mana, of tikanga and te treaty. They felt that those were the three issues that were pertinent to this particular relationship that in entering into dialogue with the Crown.
On the ability of iwi or hapu being able to go to court to explore their rights, do you think they should go to court? Because there has been some commentary suggesting it's a waste of money. Why would Māori even entertain the thought?
Well, some iwi, of course, have wanted to do that, and that's their right to do that. In other cases, iwi have wanted also to be able to enter into direct negotiation, and that's what's going to be allowed in this process. It'll be treated similarly to a treaty process where iwi can make the choice of whether they go into a direct negotiation with the Crown or whether they take their claim to the court.
Who will be able to... Sorry, just to clarify, who will be able to go to court? All Māori, any Māori with a claim?
I think anybody who has a claim to specific areas.
Because another issue that's been raised today is about legal aid and whether or not legal aid should be provided for these rights to be explored, whether it be with the Crown directly or with the court. Do you think legal aid should be provided?
Well, given that this area was confiscated by the last government, it's very important that there is a process that's made available to those iwi, and they have a treaty. In the treaty process, they are able to have legal aid. I think that because this land has been confiscated, they should be entitled to legal aid as well, but that's to be determined.
Very, very briefly, because we have to wrap up, we've got less than 30 seconds left, but 6 years later, because this is the very issue that you left the Labour Party, the Maori Party was formed. In reflection, has it been all worth it now we're at this point?
Oh, absolutely. The fact that we're approaching a time of repeal, that there is going to be access to justice, those were the significant issues over the Foreshore and Seabed, and I'm really pleased that we've got to this point.
Tariana Turia, thank you very much for joining us in Whanganui.
Kia ora.